Judgment in the matter of the King on the application of Imam against the London Borough of Croydon.
This case is about the provision of accommodation to a homeless person and her family pursuant to the duty owed to them by a local housing authority under section 193 subsection 2 in part 7 of the Housing Act 1996. Part 7 of the Act imposes a duty on a housing authority to provide temporary accommodation which is suitable for the needs of a homeless person, including taking into account any special needs that person may have by reason of disability. The duty arising under Part 7 has to be contrasted with the discretion that a housing authority has under Part 6 of the Act to assign properties on its books to be let out under permanent tenancies as council housing. The respondent, Ms. Imam, is disabled and has to use a wheelchair. She has 3 children. She is homeless. In 2014, she applied to Croydon Council as her local housing authority, asking it to provide her with assistance in the form of accommodation under Part 7 of the Act. Croydon did provide her with a house, but it is agreed that the property is not suitable accommodation because it is not fully adapted to meeting Ms. Imam's special needs. This means that Croydon accepts that for a long period it has been in breach of a binding statutory obligation it owed Ms. Imam under Part 7 of the Act to provide her with suitable accommodation. However, Croydon says it has done the best it can. It has a substantial general funding deficit, which means it cannot do more. Ms. Imam says that is not a good answer. She applied to the High Court, asking it to make a mandatory order to compel Croydon to provide her with a suitable property in substitution for the house currently allocated to her. The issue in this appeal is whether a local authority's lack of financial or other resources should be taken into consideration when a court is deciding whether to grant a mandatory order against the local authority to enforce its statutory duty towards a homeless individual under Part 7. The alternative to making a mandatory order to force the provision of such a property now is to make a quashing order to compel the authority to think again and try to work out some acceptable solution. The judge in the High Court refused to make a mandatory order against Croydon. He considered that it was a sufficient answer for Croydon to point to its general funding difficulties. The Court of Appeal disagreed with that. In its view, pointing to a general funding deficit was not sufficient. Croydon might have suitably adapted properties within its portfolio, including those which it might be thinking of using as council housing under Part 6 of the Act. If so, that would be wrong. Croydon should be given priority to using suitable properties, if it had them available, to meeting its binding obligation to Ms. Imam under Part 7 rather than using them for Part 6 purposes, which was a matter of discretion rather than duty. The court could not tell from the evidence whether that was the case, and so it was agreed that the case had to be remitted to the High Court for more evidence to be filed and for further examination of that question. Croydon says that the judge was right and the Court of Appeal was wrong on the question whether a mandatory order should be refused on the information currently available, so it appeals to this court. On the appeal, Ms. Imam also makes a complaint about the approach adopted by the Court of Appeal. She says that the court was wrong to focus on whether Croydon currently has any suitable properties in its portfolio. Even if it doesn't, a mandatory order should be made against it, which would have the effect of compelling it to spend money to acquire such a property for Ms. Imam without any further delay. This court unanimously dismisses Croydon's appeal and also rejects Ms. Imam's complaint about the Court of Appeal's approach. The judgment explains that Croydon is subject to a duty under Part 7 of the Act, which has been imposed by Parliament and is owed to Ms. Imam. At the same time, remedies in public law are a matter for the discretion of the court. That discretion has to be exercised in accordance with principle and in a non-arbitrary way. A court will not order a person to do what is impossible. The judgment examines the way in which the resources available to Croydon are relevant to considering what should and should not be regarded as impossible for it to do, according to this legal standard. The substance of the statutory duty on Croydon cannot be undermined by a simple statement that it is under general funding pressures. The judge was wrong to accept that as an excuse. The onus was on Croydon to give evidence to the court about the extent of its portfolio of properties adapted for wheelchair users and to explain why any such property which might be assigned for allocation as discretionary council housing under Part 6 could not be used instead to meet its statutory duty under Part 7 of the Act. Without such evidence, the court could not tell whether it would be impossible for Croydon to comply with a mandatory order. The case therefore had to be remitted to the High Court for further evidence to be filed in order to examine this issue. However, it would not be right for the court to go further and to make a mandatory order which required Croydon to readjust the management of its general budget in order to divert resources which it requires to meet all its other responsibilities into its housing budget in order to buy a suitable property for Ms. Imam if one is not already available in its existing portfolio. As a local authority, Croydon has a wide range of responsibilities which it has to fulfil. It has the democratic mandate and the administrative expertise required to balance its budget across the whole range, and a court should not unduly disrupt that balance by making a mandatory order in Ms. Imam's case. If Croydon does not have a suitable property in its portfolio now, it may have to be allowed a period of time to adjust its budgetary allocations in the future to shift resources to meet its statutory duty to Ms. Imam in an orderly way. The court gives guidance as to how the competing right of Ms. Imam and the wider interests which Croydon has to manage should be balanced against each other. The worse the impact on her of being denied her statutory rights, the more quickly the council will be expected to respond by adjusting its budget.